this afternoon and for taking this important initiative to promote access to legal education. The pandemic has disrupted the best laid plans, and many of you have had serious constraints in accessing this material. And I hope that this lecture series makes some amends and helps promote greater access to legal education in India. I'm Sudhir Krishnaswamy, and I'm the Vice Chancellor of the National Law School of India University in Bangalore. And the title of the talk that I will deliver today is The Preamble in the Constitution. I've chosen my title carefully to both ensure that it is an introduction for so many of you who are beginning your legal education in July and August this year, but also to anticipate and set the ground for other colleagues who will come in and take up further topics in the Constitution of India and similar areas. So let's get started. Broadly, in today's session, I want to focus on four main themes. I want to begin by tracing the history of the preamble and use that effort to glean the purpose of the preamble. There is considerable confusion on what is the place of the preamble in the Indian Constitution, and I want to use this historical overview to help us think through the place of the preamble in new and interesting ways. The second is to bifurcate the two aspects of the preamble, which is to give us an outline of the characteristics of the Indian state that the preamble describes, and the second, to illustrate the key goals of the Constitution that the preamble sets out for us. At the end of the first section, I'll outline for you what I think a useful analytical approach to thinking about the preamble and reading the preamble would be, and parts 2 and 3 on the Indian state and the goals of the Constitution will follow from that. I will close this session by spending a little bit of time on the legal interpretation of the preamble. Many of you will spend considerable amounts of time figuring out how the preamble can be used in legal interpretation. I am not going to try and cover all of that ground in an introductory lecture like this. It is a considerably difficult topic, but one that I will leave to someone else who will tackle questions of constitutional interpretation at length. So let's get started. Now, the purposes of the preamble could be could be gleaned from the text of the Constitution of India, but too often we fail to understand the historical character of the Constitution as a special kind of statute. While the history, the goals, the statement of objects and reasons are relevant for all statutory interpretation, there is a way in which a longer history of the preamble is necessary to both understand the meaning of the preamble as well as the direction in which it shows the future of the Indian nation. So I will spend a little bit of time talking about the Karachi Resolution, where the preamble is anticipated in significant ways, as also the Objectives Resolution in the Constituent Assembly, which is a direct precursor to the preamble as we find it. I will then close by paying some attention to the opening and closing words of the preamble that give us a sense of why the preamble is placed where it is in the Constitution. So let's get started. Why do constitutions need a preamble? Why couldn't the Constitution of India just begin with Article 1? Is there a solemnity or a legal purpose that the preamble serves? These are useful questions to begin a discussion of the preamble with. A simple answer might be to read the preamble as simply a glorified way of saying that this is a preface or the introduction to a book. Most books that you would pick up would have a preface that would tell you a little bit about the author's motivations and life experiences that have led to the creation of the book. So maybe the preamble is just that. It's a statement by the founders of the Indian Constitution, the framers of the Indian Constitution, about their motivations and the conditions under which the Constitution was produced. But please notice in the preamble that you see no reference to the Constituent Assembly, barring the last the last section of the preamble, and no reference to the 3 long years spent creating the Constitution. So it is not likely that the preamble is a preface of the ordinary sort. A preliminary reading of the preamble and its opening words, and I think it's opportune for me to just do that reading now. It goes like this. It says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and I'm going to stress this, that these are the two parts of the preamble, and to secure to all its citizens justice, liberty, equality, and fraternity, in our Constituent Assembly do hereby adopt, enact, and give unto ourselves this Constitution." So let's pay some attention to the structure of the preamble. It begins by telling us about the nature of the Indian state that is constituted by the Constitution of India. In other words, it tells us about the goals and the ideals that the framers seek to build into the Constitution. But first and foremost, by building a certain kind of political entity, a polity that is sovereign. And we know that the words socialist and secular were introduced at a later stage. The preamble of 1950-49 read sovereign democratic republic. These are all features of the political entity that is India, that the Constitution creates. Now, there's much debate about the 1950 and the later insertions into the preamble. It's not a debate that I will join today. It's worth engaging with all on its own. But for the moment, it's useful for us to identify that the first part of the preamble is about the nature and the form of the Indian state, the Indian polity. The second part, which follows from the phrase "to secure to all its citizens," seems to set out some fundamental goals of the Constitution. To secure, we want to create a society that is enshrined around the values of justice, liberty, equality, and fraternity. We can go into each of these values and the brief descriptions that follow in greater detail. But what it tells us is it anchors our understanding of the purposes for which this political entity called India is created. Now we understand from the last part of the preamble that this is an enactment clause, but this is not an enactment clause of the sort that you would find in an ordinary statutes, because the Constitution of India is adopted, enacted, and given unto ourselves, which gives you a discrete image that this is a self-creation. This is a sovereign creation. Almost by word, we we artificially but really create a new political entity built around a common structure of a polity and around common goals. It's the creation of this new political community that the preamble signals in its barest outline. So, coming back to the question, why do constitutions need a preamble? It is quite clear that the Indian Constitution is not designed as a pedantic preface or an introduction. What it indeed does is to capture the core structures and goals of the Constitution that is to follow, almost the purpose of the entire Constitution that is to follow. The second question that I want to ask and try and respond to in a meaningful way is to ask, where does the preamble come from? Now, when we say where does it come from, we immediately understand that the preambular statement, at least with its opening words, "we the people," resembles the US Constitution's opening words. So I don't mean it in that sense. What I'm asking and trying to answer is, where does the Indian preamble come from? Was it just written in the 3 years that the Constituent Assembly sat? And I'm going to suggest to you that we would do well to go beyond and earlier into the history of the freedom movement to understand the motivations for the preamble. The first place I want to stop is the Karachi Resolution, which was declared on the 29th of March 1931. There were three important events in the Indian freedom movement, three important political events that the Karachi Resolution encodes. The first was that Gandhi was released after the Salt Satyagraha. We all know that Gandhi endured several bouts of imprisonment at the hands of the imperial state. The Karachi Resolution was adopted at the end of one of these long bouts of imprisonment. The second is that the Gandhi-Irwin Pact led to the end of the civil disobedience movement. So the civil disobedience movement had reached something of a crisis point, and the Gandhi-Irwin Pact was a method by which the civil disobedience movement was wound down. Third, Bhagat Singh, Rajguru and Sukhdev were executed on the 23rd of March 1931 in the Kakori conspiracy case. Now, for those of us who pay attention to these background historical events, we realize that the Karachi Resolution draws from these major events. What did the Karachi Resolution commit us to? The first was that it is the freedom movement's declaration to Purna Swaraj, or to complete independence. But in that document, so not only are we claiming independence, but in that document you find the early form of the fundamental rights, the civil liberties that the future constitution will protect. And we also see the socio-economic principles and rights that the Indian Constitution encodes in a separate chapter. The Karachi Resolution is a comprehensive document that anticipates some of the core values that the Indian preamble states explicitly and clearly. When we look at the Karachi Resolution, why do I stress this point? I stress this point because I want to emphasize that the values chosen in the preamble, whether they be the values describing the Indian state, or whether they be the values of the goals of the Constitution, were not just arbitrarily chosen in 2 or 3 years by the Constituent Assembly. They were rooted in the Indian freedom movement in 100 or more years of a political movement that came and learned from its experiences that these values are critical to the future of the Indian state. The Karachi Resolution includes statements like these, and I just want to read them so that we get something of the texture of what was said. The Congress is of the opinion that in order to end the exploitation of the masses, political freedom must include real economic freedom of the starving millions. In order, therefore, that the masses may appreciate what Swaraj as conceived by the Congress will mean to them, it is desirable to state the position of the Congress in a manner easily understood by them. The Congress therefore declares that any constitution that may be agreed to on its behalf should include the following items, or should give the ability to the Swaraj government to provide for them. This kind of express anticipation of where a future constitution would go gives you a sense of the importance of the Karachi Resolution. The values inscribed in the Karachi Resolution have come back into the Indian constitutional debate, not only in the preamble, but in the run up to the preamble on the 13th of December 1946, in the Objectives Resolution that was tabled in the Constituent Assembly. Now, the Objectives Resolution and its meaning in a historical sense is something that is the subject of much academic debate, and a debate that is worth spending some time on and understanding. When Nehru introduced the resolution on the 13th of December 1948, he made it very clear that the Objectives Resolution is a resolution like any other, but it is much more than a resolution. He almost crafted it as if it were a pledge. And he spoke about it in these terms. It is an undertaking with ourselves and with the millions of our brothers and sisters who live in this great country. If it is passed, it will be a sort of pledge that we shall have to carry out. When we read the Objectives Resolution and its express reference to a pledge-like character, we understand that the preamble, which now codes the Objective Resolution, has this feature, the feature of being a political pledge. Mind you, pledges are statements of political obligation. They're not, and moral obligation. They're not always statements of legal obligation. That is certainly the tone and the language in the Constituent Assembly. The Objectives Resolution was very direct. It expressly committed to constitute India as an independent, sovereign republic comprising a union of states. It also clearly stated that the Union of India is the product of the will of the people of India. It captures many of the aims and aspirations that drive the making of the Constitution, including socio-economic and political justice, equality of status and opportunity, freedom, and safeguarding the rights of the minorities. Now, even this very basic reading of the Objectives Resolution, and I'm only summarizing the resolution, will give all of us careful pause to say that many of these values find themselves in the preamble to the Constitution. So the Objectives Resolution, much like the Karachi Resolution, well anticipate the preamble to the Constitution. Now, we know that the Objectives Resolution went through very sharp and divisive debates, especially because it was tabled in the absence of the Muslim League, which was a member of the Constituent Assembly at that point. It was also used by the Muslim League as a reason, or as one of the reasons to leave the Constituent Assembly altogether and to press for a separate nation. Along with the Muslim League, the princely states were also left out. At that point, they were yet to become members of the Constituent Assembly. And hence, federalism, which doesn't find a strong statement in the Objectives Resolution, was a point of some contention both for the Muslim League as well as for the princely states. Other issues, including the rights of minorities and socio-economic rights, were discussed at length in further sessions. But all said, the Objectives Resolution anticipates significant features of the Constitution and anticipate the structure of the preamble of the Constitution. It was finally adopted on the 22nd of January 1947 and came to be placed at the start of the Constitution as the preamble. When we turn back, and I'm going to go back now to a basic reading and the text of the preamble, we recognize that we, the people of India, resolved to constitute India. And this opening phrase seeks to distinguish the idea that India was some pre-existing country that has existed for, I don't know, 3,000 or 5,000 years. It was not created by God. It was not created by the British Empire, but it was created by the people of India, by popular approval, by popular sovereignty. So this opening phrase of the preamble communicates that it's the individuals that make up India that created this constitution. Not castes, not communities, not religious groups. So it's not the groups or the peoples of India who created the constitution, but the individuals who come together to form the body politic of India, who created this constitution. It's a good time for us to just take a quick step back and notice that this is not standard form. If we look at the Constitution of South Africa, which was created in 1996, we notice some salient differences to the Indian model of how you create a constitution. The South African Constitution, and I'll just alert you to some significant features of its opening statements. It says, "We, the people of South Africa, recognize the injustices of our past." Notice that the Indian Constitution is not historically self-conscious, nor is the preamble. It doesn't talk about colonialism and imperialism. It goes straight into it. It's very forward-looking. It talks about the future of the polity that is India. Doesn't make references to the past. The South African Constitution goes further. It says, "We honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity." We know that the Constitution of South Africa was created after a long struggle against a racist apartheid past, and hence the Constitution of South Africa, without mentioning the word apartheid or that past history, captures that background in the way the preamble is written. The Indian Constitution does no such thing. It does not talk about British colonialism and imperialism, as I just mentioned, nor does it talk about the history of the freedom movement. Now, those of us who pay attention to these texts carefully and these histories would do well to remember that the absence of these historical facts in the Constitution is simply a stylistic matter. We would do well to read the preamble against this background history. The Constitution of Nepal 2015, our closer neighbor and closer in time to where we are today, has a similar opening statement. It says, remembering the glorious history of historical people's movements and armed struggles time and again, and the sacrifice made by people for national interest, democracy, progressive change, and recognizing the martyrs, the disappeared citizens, and the victims, and so on. So, once again, like the South African Constitution of 1996, the Constitution of Nepal of 2015 is very specific in its historical references. The makers of the Indian Constitution, our founders, chose not to go down that path. They chose to write a document that makes no concrete historical references, and they leave it to us to find out and unearth and understand that broad history. So I've said a few things about the history of the preamble to the Constitution of India, and that gives you an insight and a lineage by which you can understand that preambular statement. I'll now shift to part 2 of this lecture, where I will focus on the features of the Indian state that the preamble adopts as being the key features of the Constitution. So I mentioned earlier that there's the 1950 and then the later amendments, but for the purposes of this talk, I'm just going to deal with all of them in one sequence. So we created a sovereign, democratic republic that is socialist and secular. Now, each of these terms have a historical reference, a prehistory prior to the preamble, and we want to pay attention to every one of them as we go ahead. Why do we need to state that the India that we have created in the preamble is a sovereign democratic republic? Please remember, and we lose sight of this at in some moments now that we have 7 decades of an unbroken political independence, that prior to 1947, India was ruled by the Queen of England. The proclamation of Queen Victoria as the Empress of India in 1858 is an important historical and legal marker when the British Empire asserts sovereignty over India. It is only in 1950 that we reassert our own sovereignty and political control. Mind you that Nehru made it very clear that the sovereignty of India did not prevent us from being a part of the Commonwealth. So India took this narrow path of asserting sovereignty, but nevertheless remaining in the Commonwealth and acknowledging our historical membership in the Commonwealth. So that's the first point, the point about sovereignty. The second is that the authority of the state was not one that could be exercised either by dictatorial power or by inherited power, but one that would emerge from the vote. The adoption of the democratic principle in a poor developing country is not a foregone conclusion. In fact, in the 1950s, most political commentators were very surprised that India might choose to go down the universal adult franchise route and would have an elected prime minister who would be the leader of the political entity, that is democratic India. Now this choice, once again, the democratic republic, is not a choice that was made fitfully in a period of 2 or 3 years. The commitment to universal adult franchise predates the Constituent Assembly in the freedom movement. it was the experience of the freedom movement and the necessity of building a mass freedom movement, not one ruled by elites, that led to the commitment to the democratic principle. Hence, democracy was put into the preamble as a core founding value of the Indian state. The third value that we find is the idea that India will be a republic. Now, one way of thinking about the value of republicanism is to simply insist that we no longer will be ruled by Her Majesty the Queen. And this is a fair legal point. But the bigger idea of republicanism was to create a society that was not bound by hierarchy, whether those hierarchies be of caste, class, or gender, that was built around a spirit of public participation in the democratic political activity and the governance of the Indian state. This second feature of republicanism, as going beyond the hierarchies, the inherited hierarchies of the 1950s, is a feature that is often lost, and most current commentaries and texts on the Constitution simply emphasize that we chose to become a republic to replace the Queen as our head of state. So let's go over these first three values: sovereign, democratic, and a republic. But this was not all. As we know, we have added two more features to the preamble through amendment at a later point. Now, there is some debate whether these features, socialist and secular, were originally the motivations of Constitution founders or just later additions. And I want to spend a little bit of time on this, even if not too much. The first thing I want to do is to note that K.T. Shah in the Constituent Assembly had already proposed an amendment to the preamble to introduce the words secular, federal, and socialist. And there was something of a debate on whether these words, this amendment, should be included or not. Now, what is striking is that that word socialist was not included in the preamble for a couple of reasons. One, that many of the founders of the Constitution felt that the provisions of the Constitution anyway described a society committed to socialist principles. So they thought it was superfluous to add the word socialist into the preamble. The second and the more nuanced point, and I'm going to read a small extract of a speech by Dr. B.R. Ambedkar on 15th November 1948, and he observes, what should be the policy of the state, how the society should be organized in its social and economic side, are matters which must be decided by the people themselves according to time and circumstance. It cannot be laid down in the Constitution itself, because that is destroying democracy altogether. This point made by Ambedkar is a point that seems to push back against the introduction of too many value statements in the preamble. In other words, let the democratic process and the people, through election and beyond, choose their values. Let it not be chosen for them by the founders of the Constitution. As things go, this was not the socialist word was not taken into the Constitution. It did come in at a later point by the 42nd Amendment of 1976 through the post-emergency amendments as a result of the recommendations of the Swaran Singh Committee, and it arose against a very different debate about the relative weight of the directive principles and the fundamental rights. So I take it that the 1976 introduction of the word socialist had much to do with the Supreme Court's interpretation of the Constitution rather than the earlier debate that occurred in the period 1946 to 1950. What is also important to recognize is the debate around socialism in India was quite unique. India's view on socialism was that we had our own version of socialism. It was not a revolutionary socialism of a Maoist or communist sort, but a Fabian socialism that emphasized incremental and careful regulation of markets to ensure that markets delivered to the widest social constituency. So even when we adopt the word socialist in the Constitution, in the 42nd Amendment Act, in response to the Supreme Court's interpretation in the first 3 decades of the Republic, we understand that this socialism is a socialism that is distinct to India, not a socialism that is borrowed from foreign shores or from other experiences. So we then had the Constitution of India in also get amended. Sorry, the preamble also got amended by the 42nd Amendment to put in place the word secular. Now, here too, I'm going to press a similar argument that the word secular was introduced in 1976 not because there was suddenly a doubt about whether India should or should not be a secular polity. This matter was discussed at some length in the Constituent Assembly, and there was almost the point of contrast at that point in 1947 to 1950 was the contrast between the Pakistani adoption of a more religious model of the state and the Indian distinction from the Pakistani experience by emphasizing a secular mode. So that point was already appreciated and decided in the Constituent Assembly. The adoption in 1976 is much more in response to a particular set of challenges that emerged to the Indian state by that point. And the emphasis once again is on the distinctiveness of Indian secularism. The Indian secularism is not the separation of church and state as practiced in US constitutional doctrine. It's also not the laïcité model of the French constitutional variety. The Indian model around secularism was one that was evolved through multi-religious and spiritual practices that were integrated into the freedom movement as being a mode of political organizing. So in 1976, when we introduced these two terms, I would urge that we should understand them against this wider historical background stretching back almost 100 years. So much for part 2. So in part 2, I focused on the core values of the Indian polity, namely the sovereign democratic republic that will be socialist and secular as well. The third part of this lecture emphasizes the goals of the Constitution. Now, you will remember that when I read the preamble, I emphasized that that second part begins with the phrase to secure to all its citizens. That is, that the reason we established this state, what state? The sovereign democratic republic, which is socialist and secular, we established this kind of state to secure for all its citizens justice, liberty, equality, and fraternity. Now remember, it suggests a tension that if the state, if this sovereign democratic state doesn't secure to all its citizens liberty, then there is no point in having such a state. So the preamble has these two elements. It tells us about the nature of the polity and the nature of the goals set out for the constitution. So let's get into these goals with a little more detail. The first goal of justice has a further description, which suggests that we want many dimensions of justice: social, economic, and political. Now, this multi-dimensional justice must be viewed against the framing history of the Indian Constitution. It is not just the reducing of inequalities of income and economic opportunity which is the purpose of the Constitution, but also the removing of the fundamental feature of subcontinental culture and history, which is the prevalence of caste discrimination. Now, all of us know that Dr. B.R. Ambedkar, in the Annihilation of Caste, as well as in various representations to the Round Table conferences and representations to the British government in India, made it very clear that Indian democracy would not go very far unless we ensured that political justice and economic justice were closely followed by social justice. And this recognition is placed right up in front in the preamble to the Constitution. Political justice is ensured by the equal right of all to participate in the political system. Article 326, which puts in place universal adult suffrage, and Article 325, which prevents any discrimination against any person on the electoral roll of every constituency on the basis of religion, race, caste, sex, or any of them, is constitutionally prescribed. So you know that many of the debates that currently are ongoing in the United States about voter discrimination is anticipated and responded to by Articles 326 and 325 of the Constitution. So that deals with the question of political justice. But economic and social justice is to be found in various places in the Constitution, but the directive principles of state policy and the fundamental rights chapter put in place some serious protections to ensure that these goals are pursued by the independent republic. The second major goal is the goal of liberty, but the liberty goal is spread out in various places. It includes the liberty of thought, expression, and belief, and we know that Article 19 captures much of this. Faith and worship, which is placed between Articles 25 and 28, and let me say a little bit about each of these. The adoption of liberty as a core value of the Constitution, a core goal of the Constitution, makes it clear that India adopts a democratic political model that also offers liberal protections. We are not here for an authoritarian democracy, but for a liberal democracy that protects individual freedoms, their thoughts and beliefs, as well as their freedom to express them in words and conduct. The second dimension, faith and worship, which is in the preamble, is captured in 25 to 28, but as I mentioned before, is a strong rejection of a theocratic state model, right? But if we give these kinds of protections and commit ourselves to the liberty of faith and worship, we are, in other words, affirming the secular principle. Now, these commitments to protect both religious beliefs and other beliefs are placed at the core of the Constitution. The third goal that is set out has some bearing on the question of justice, but is restated very strongly to include the equality of status and opportunity. Article 14 encodes a general protection to equality before the law and the equal protection of the laws. 15 and 16 put in place an anti-discrimination principle, and when read with Article 39 and others, also put in place the need to make special provisions for those who are disadvantaged. Now, the point about the equality of status and opportunity is not simply a point about anti-discrimination. The Indian Constitution commits itself to the positive measures that one must take to make equality of status and opportunity real in a reasonable period of time. We also know that Article 17, with the abolition of untouchability, and Article 18, with the abolition of titles, seeks to ensure that not only do we attack pre-existing caste practices, but we also prevent the emergence of feudal or royal titles which might be hereditary or conferred by state. Now, this commitment to make what is effectively a social democracy as well as a political democracy is a unique feature of the Indian Constitution. There are many great revolutions, the French, the American, and the constitutions that followed did not commit themselves to such a wide-ranging project of changing the nature of social relationships. They were content with transforming the political. But the preamble makes clear that the Indian Constitution attacks both the political but also the social. Now, in recent years, much has been written about the place of the word fraternity, the value fraternity, as a core goal of the Indian Constitution. It is significant that the word fraternity did not appear in the objectives resolution. But there are references, at least a couple that I want to mention, that are found in the Constituent Assembly that give us a sense of why fraternity was placed in the preamble. Ambedkar, on the 25th of November 1949, spoke about fraternity in these terms. He says, fraternity means a sense of common brotherhood of all Indians and of Indians being one people. It is the principle which gives unity and solidarity to social life. J.B. Kripalani, very different kind of figure in the Constituent Assembly, said something like this: fraternity is allied to democracy. It is a moral principle to be lived in life. These kinds of references invite us to think about whether fraternity is imagined in the Constitution as a political or a social principle. In other words, is fraternity a principle that must be promoted by the state, or is fraternity a principle that must be promoted by social organizations, families, civic associations, so on? It appears that by placing it in the Constitution, and that too in the preamble, there's no further reference in the text of the Constitution to fraternity, though one can identify various provisions that draw on the fraternal principle. But fraternity, by placing it in the preamble, it appears that the Indian Constitution makers seem to have recognized the imperative that the Indian state, that is the state that is created by the Constitution of India 1950, must embrace and must intervene in creating the conditions for this social principle of fraternity to be practiced. Once again, while we can find some philosophical justifications for this position, in constitutional terms, the Indian Constitution adopts a very striking approach by embracing the principle of fraternity. With that, I finish the third part of this lecture, where I focused on the core goals of the Constitution. I noticed that I'm also tight on time, so let me push ahead and do a quick cursory overview about how one might interpret the preamble in our contemporary times. Much of what I've said so far could be understood as an explanation of the political meaning of the preamble. I have said little, though some political meaning may find its way into legal meaning. I've said very little directly about how the preamble should be legally interpreted. So let me just share a little bit and in this closing section on how I think we might begin an exercise of thinking about the interpretation of the preamble. Now, we noticed that the preamble, the text of the preamble, emphasizes that it is created by we the people of India in our Constituent Assembly, thereby really enshrining the special representative claim of the Constituent Assembly. Constituent Assembly is a special assembly. It's not just an ordinary legislature. It was created for one and only one purpose, which is the drafting of a constitution. The language of the preamble emphasizes that this Constituent Assembly is this special body that can give us this constitution. Parliaments may have limited power, and as we know in the subsequent interpretation of the Constitution, at least from 1973, we recognize that the Constituent Assembly stands in a special relationship to the Constitution than any parliament, subsequent Parliament of India created by the Constitution. So this is a very important legal concept that emerges from the phrasing of the preamble. The second is that the preamble makes clear that we adopt, enact, and give unto ourselves this constitution. Normally, statutes, ordinary statutes, would only say that the statute is hereby enacted by a state legislature on this date. The constitution is adopted by the people, for the people, and it suggests this unique way in which the constitution is created. This emphasis on the political authority for the constitution being the people themselves makes clear that the only body that might be able to change the constitution is the people themselves, acting in some unique representative manner. Now, these two features, for those who are students and scholars of constitutional law, we understand has been picked up by the Indian Supreme Court in the mid-70s to frame what we now know as the basic structure doctrine. What about the preamble in the courts? Is it directly enforceable? No. We are clear that the preamble, so no one can find themselves in court pressing a court to directly implement the preambular value of fraternity. There is no space and form for that kind of a direct enforceable claim. However, preambles can have significant indirect interpretive effects. And I'm going to just look at two ends of the debate of the place of the preamble in the courts as I wind down and close this session. The first is that in the early cases of in the matter of Berubari Union in the 1960s, The Supreme Court took the view that the preamble cannot control the unambiguous language of the articles of the Constitution. In other words, the preamble cannot frame the interpretation of the Constitution. When the text of the Constitution confers powers or imposes limitations and obligations on any party, the preamble cannot change that. In the 1980s, we get the view in Minerva Mills and the Union of India that the preamble holds the kernel to the basic features of the Constitution. What had happened in 1973 is that the Constitution, that the Supreme Court, identified the basic structure doctrine and the basic features of the Constitution as a limit to the amending power of Parliament. So between Berubari Union and Minerva Mills, we understand that the preamble has come to exert some legal limits on the powers enshrined in the Constitution. Now, this might be overstating the case to the extent that we think that one might go in and litigate the preamble directly. But I made that very clear that this is not an argument about direct enforceability, but about the preamble having ways in which it controls the interpretive meaning, the scope and interpretive meaning that we give to the Constitution of India. And I think that point is reasonably settled and secure at this point in Indian constitutional interpretation. But as this is an introductory lecture, the first of many more to follow, I will leave it to others to take you through the Byzantine bylanes of Indian constitutional interpretation as we work our way through the constitutional lecture series. So for now, I'd stop here. Thank you once again for joining this introductory session. I hope you find this useful. Always feel free to get back to me if there's something that I've said that has been unclear. Easy to find me on the website of the National Law School of India. Wish you all the best and look forward to contributing to future sessions. Thank you.